Deep. Very serious.
Hi, everybody. This is Ed, not AI, from Ed Talk, which is better than a TED Talk on deep dive true crime. Here's another update about the Donna Adelson case. It seems that the defense finally complied with a deadline imposed by Judge Everett. Several filings took place by Monday's deadline, so now it looks more likely that the trial in the Donna Adelson case will happen as scheduled, starting with jury selection on August 19th. The primary filings included several motions in limine by the defense, motions seeking rulings on admissibility ahead of the trial, a witness and exhibit list by the defense, and an updated witness list from the prosecution. In this video, we will go over the motions in limine and the state's second amended witness list. We will not discuss the defense disclosures at this time, as we are still evaluating those disclosures. Okay, first, I will discuss some of the entries in the state's second amended witness list. The witnesses there who did not testify before include the following. 1. Numbers are from the list. 1. Investigator Brittany Adams, who helped with the new investigation into the alleged witness tampering scheme. 6. Drina Bernhardt, one of the jail informants. 9. Kate Butler, the handwriting expert who will compare Donna's handwriting in her calendar to the writing in the script given to Drina. 10. Patricia Bird, the second informant from the jail. 13. Amanda Collin, Leon County Jail officer, regarding the new investigation. 27. Tara Kawas, Catherine Magbanaw's defense attorney, possibly about the events between Sigfredo's arrest and her arrest. 32. James Lewis, first defense attorney for Sigfredo Garcia. 34. Francis Magbanawa, Catherine Magbanawa's brother. We republished his FBI interview a few days ago. 36. David Marcus, first defense attorney for Charles Adelson, likely regarding communications between him and Tara Kawas. 42. Dr. Jerome Obed, the dermatologist who was roommate of Charles Adelson and employer of Catherine Magbanawa. 43. Scott Radius, a friend of Charlie in Vietnam who helped purchase a timeshare and who reported to law enforcement Donna's plans to travel to Vietnam. 59. Sharon Williams, another officer from the Leon County Jail, the new investigation. And 61. Sarah Youssef, lawyer and former close friend of Wendy Adelson, who heard derogatory statements from Donna shortly after the murder. As for the motions in limine, the first one is the weakest, the defense asking Judge Everett to reconsider his ruling on whether the state can offer Donna's plan to travel to Vietnam as, quote, consciousness of guilt, unquote, evidence. Given the urgency and timing of her trip and her efforts to keep the plan secret, as well as entries in the calendar, which surprisingly may not be used at her trial, this seems to be the most ridiculous of the motions. Donna's explanation for her plans to travel to Vietnam was also ridiculous. This is clearly a jury question. Nevertheless, let me go ahead and read the motion. Defendant's renewed motion in limine, travel as consciousness of guilt. Defendant Donna Adelson, by and through her undersigned counsel, renews her August 12, 2024 motion to preclude evidence of Donna Adelson's travel as consciousness of guilt, and in support thereof states as follows. 1. Mrs. Adelson has been indicted in this case with 1 count of first-degree murder, 1 count of conspiracy to commit first-degree murder, and 1 count of solicitation of first-degree murder. 2. On August 12, 2024, prior counsel filed their motion to preclude evidence of Donna Adelson's travel as consciousness of guilt. On August 30, 2024, the court denied this motion, ruling that, quote, I do believe this is a matter that goes to weight versus admissibility. The finder of fact, the jury, is going to determine whether Mrs. Adelson was, in fact, merely researching a vacation or if she was, in fact, seeking to avoid prosecution of this as consciousness of guilt. Really, it's not for the court to exclude, as it is relevant and probative. 3. New facts and known but not previously argued warrant the court revisiting this ruling. 4. Specifically, during Jason Newland's July 9, 2025 deposition, Newland admitted that prior to the warrant for her arrest being issued, Mrs. Adelson was free to travel and leave the country. 5. Namely, that at the time Mrs. Adelson purchased her ticket to Dubai and Vietnam on November 7, 2023, and traveled to the Miami International Airport on November 13, 2023, she was unaware a warrant had been issued for her arrest and nothing prevented her from traveling. 6. Additionally, Scott Radius testified at his August 21, 2024 deposition that Newland told him that there, quote, is no bench warrant for the arrest, so they can leave the country if they want, unquote. 7. Finally, Maricel Descalzo, Mrs. Adelson's then attorney, advised Mrs. Adelson after Charlie Adelson's conviction that there was no warrant for her arrest and she could travel. Ms. Descalzo also advised that she had an agreement with the state that, if a warrant were issued for Mrs. Adelson, that Mrs. Adelson would self-surrender to the Leon County Detention Center. 8. Based on these additional facts, and conducting the analysis required by both the case law and Section 90.403 Florida statutes, Mrs. Adelson requests this court revisit its August 30th, 2024 ruling and prohibit the state from arguing that her travel was consciousness of guilt. Wherefore, the defendant, Donna Adelson, respectfully requests that this honorable court grant this renewed motion in limine, prohibit the state from arguing that Mrs. Adelson's flight is evidence of consciousness of guilt, and for such further relief as is just and proper. Signed, Attorney Jackie Fulford and Joshua D. Selman. Next, there are two motions in limine that actually make some sense. The motions ask the court to preclude opinion testimony. Both are good motions that should be easily granted, but they could and probably should be raised during trial. It would seem unlikely that the state would be soliciting opinions from the detectives. Nonetheless, it is smart for the defense to get ahead of the issue and have the court on the lookout in case the witnesses try to throw in improper opinions during their testimony. Let me read to you the relevant portions of those two motions. First motion, defendant's motion in limine, opinion testimony of Jason Newland and Patrick Sanford. Defendant Donna Adelson, by and through her undersigned counsel and pursuant to Section 90.403 and 90.701 Florida statutes, requests that this honorable court exclude opinion testimony of Jason Newland and Patrick Sanford, and in support thereof states as follows. 1. Mrs. Adelson has been indicted in this case with one count of first-degree murder, one count of conspiracy to commit first-degree murder, and one count of solicitation of first-degree murder. 2. On July 9, 2025, investigator Jason Newland was deposed. On July 16, 2025, Special Agent Patrick Sanford was deposed. 3. During their respective depositions, both Newland and Sanford expressed opinions on the new investigation. Footnote: excerpts of their deposition testimony will be provided to the court with a request to maintain those excerpts under seal. End footnote. 4. By this motion, Mrs. Adelson moves to exclude opinion testimony of both Newland and Sanford. Discussion. 5. The threshold question for admission of evidence is relevance. 6. Section 90.701 Florida statutes permits lay witnesses to offer opinion testimony in limited situations. Namely, it provides that, quoting, if a witness is not testifying as an expert, The witness's testimony about what he or she perceived may be in the form of inference and opinion when 1. The witness cannot readily and with equal accuracy and adequacy communicate what he or she has perceived to the trier of fact without testifying in terms of inferences or opinions, and the witness's use of inferences or opinions will not mislead the trier of fact to the prejudice of the objecting party, and 2. The opinions and inferences do not require a special knowledge, skill, experience, or training, unquote. 7. However, under this exception, quoting, opinion testimony is usually limited to matters relating to distance, time, size, weight, form, and identity, which are easily observable. See Manicon v. State. 8. The opinions expressed by Newland and Stanford do not concern distance, time, size, weight, form, or identity. Rather, they concern the truthfulness of allegations raised during the new investigation, allegations the vast majority of which are not corroborated by any evidence. 9. Newland's and Sanford's opinions concerning the new investigation are inadmissible. See Martinez v. State, holding a witness opinion about the guilt or innocence of the accused is inadmissible. 10. Even if their opinions concerning the new investigation were admissible as lay opinions, such testimony should be prohibited as its probative value is substantially outweighed by the danger of unfair prejudice under Section 90.403 Florida statutes. Wherefore, the defendant, Donna Adelson, respectfully requests that this honorable court grant this motion in limine, enter an order prohibiting Newland and Sanford from offering their opinions concerning the new investigation during her trial, and for such further relief as is just and proper. Signed, attorneys Jackie Fulford and Joshua D. Zellman. Motion in limine number 2. Defendant's motion in limine, interpretation of emails, recorded phone calls, and text messages. Defendant, Donna Adelson, by and through her undersigned counsel and pursuant to Section 90.403 and 90.701 Florida statutes, requests that this honorable court exclude any testimony interpreting the content of emails, recorded phone calls, and or text messages, and in support thereof states as follows. 1. Mrs. Adelson has been indicted in this case with 1 count of first-degree murder, 1 count of conspiracy to commit first-degree murder, and 1 count of solicitation of first-degree murder. 2. Throughout the prior trials, state witnesses have testified concerning their interpretation of 1. Mrs. Adelson's emails, 2. Statements made by various parties on recordings, and 3. Text messages. 3. By this motion, Mrs. Adelson moves to exclude testimony of witness interpreting emails, recorded statements, and text messages. Discussion. 4. The threshold question for admission of evidence is relevance. 5. Section 90.701 Florida statutes permits lay witnesses to offer opinion testimony in limited situations. Namely, it provides that if a witness is not testifying as an expert, the witness's testimony about what he or she perceived may be in the form of inference and opinion when 1. The witness cannot readily and with equal accuracy and adequacy communicate what he or she has perceived to the trier of fact without testifying in terms of inferences or opinions, and the witness's use of inferences or opinions will not mislead the trier of fact to the prejudice of the objecting party, and 2. The opinions and inferences do not require a special knowledge, skill, experience, or training. 6. However, quoting, under this exception, opinion testimony is usually limited to matters relating to distance, time, size, weight, form, and identity, which are easily observable. See Manicon v. State. 7. In Thorpe v. State, the court reversed the defendant's conviction and remanded for a new trial after finding the trial court improperly permitted a witness to testify to their interpretation of what the defendant said during a conversation. 8. During trial, the witness was asked to opine what the defendant meant when she when the defendant made a statement. The defense objected, arguing that the question called for the witness to speculate, that his interpretation was irrelevant and the witness was not qualified to offer his opinion. The trial court permitted the testimony. 9. On appeal, the Florida Supreme Court held that, quote, as a general rule, lay witnesses may not testify in the form of opinions or inferences. It is the function of the jury to draw those inferences. Since the witness was able to convey what the defendant said, the exact meaning of Thorpe's words and the inferences that may have been drawn from Thorpe's statement should have been made by the jury and not by the witness, unquote. 10. Although it would be appropriate under the rules of evidence for a qualified witness to interpret coded conversations, testimony which interprets clear conversations does not aid the jury and is inadmissible. See McSweeney v. State. 11. Even if their testimony were admissible about the meaning of the words, such testimony should be prohibited, as its probative value is substantially outweighed by the danger of unfair prejudice under Section 90.403 Florida statutes. Wherefore, the defendant, Donna Adelson, respectfully requests that this honorable court grant this motion in limine, enter an order prohibiting witness from testifying to the interpretation of emails, recorded conversations, and or text messages, and for such further relief as is just and proper. Signed, attorneys Jackie Fulford and Joshua D. Zellman. All right. That is it from today. We will keep looking at the docket and will bring you more updates as they happen, and we hope you will honor us with your views when we cover this trial from gavel to gavel. Until next time, I'm Ed, not AI, Deep Dive True Crime, and Dan Markel's Murder Saga. And yes, don't forget to subscribe to that channel dedicated only to the Markel case. In time, most of the content from the case will be transferred there.
Thank you for watching today's deep dive. If you found this case interesting or have any thoughts, feel free to leave a comment below. Remember, this community thrives on smart and respectful discussion. Don't forget to like, subscribe, and hit the bell to stay on track with our new case videos. We cover new details, court hearings, interviews, interrogations, and more. This is Maya with Deep Dive True Crime and Mentor Lawyer Justice Network, and I'll see you all in the next video.